Parker.
Mr. Speaker, I want to speak in support of the Legal Services Bill. Before I do, I think it's good that members here have been a bit careful against criticising all people who work on the legal aid rosters, because most people who work on the legal aid rosters do a good job and don't overcharge. Nonetheless, Dame Margaret Baisley did find evidence of poor practice, and I must admit that I was surprised on Select Committee to learn that some legal aid lawyers doing low-level criminal cases were earning $250,000 per annum at the cost of taxpayers in South Auckland. And that seemed to me to be a bit excessive for low-level legal aid cases. And so when we also heard from, and not just Dame Margaret Baisley's complaints, we also heard from Justice Hanson, retired, I think he's Sir John Hanson, is he now? He was the executive judge in the South Island, Executive High Court judge for a long time, and a very practical man as well as a good judge. And he said that one of the problems was the method of allocation of legal aid briefs. And so he supported the change that was proposed by the government in this legislation to change what was the preferred lawyer, effectively choice that was always given to a litigant to choose their own lawyer. Now, there are occasions where it's important that you do have continuity of lawyer. You can have language barriers. We also heard that there are instances where some of the some of the accused are suffering underlying mental health problems, and there's been a history of involvement by a particular lawyer with that particular accused, which is helpful to everyone to have continuity with, because otherwise you're having to go back over ground that's previously been traversed, and some of the issues relating to mental health difficulties and things should be brought to the court's attention, and the administration of justice is improved through the facilitation of that by a lawyer who's previously been involved. But that doesn't mean to say that in all cases there should just be automatic right to choose your lawyer, because we've found that in these cases there has been, perhaps it's been associated with some of the abuses that there have been of the legal aid system. So, Mr. Speaker, we agree that the removal of the preferred lawyer, or the right of the person who's getting their legal expenses paid by the Crown to choose the lawyer that they want to, it shouldn't always be there for minor cases. It becomes a bit more difficult for more important cases where someone might be at risk of losing their liberty for a longer period of time because it's a more serious case. Then we think that it is appropriate that the person who's accused has some control as to who is the lawyer that's representing their interests. Now, some people say you should never have legal aid. Well, I actually disagree with that. That's a wrong proposition. Partly because the court processes are generally made, they're improved through people having legal representation, and people who are of low income, who are charged with a crime, cannot afford a lawyer often, and if you leave them without a lawyer, they both suffer a different outcome to someone who can afford a lawyer, and that doesn't seem to be a good principle of justice, that you have a different outcome according to the amount of money that you've got in your wallet, but also because there are flow-on costs to the Crown in terms of less efficient court processes and the cost of ongoing disputes where people feel that they haven't had a fair trial, and they will be more likely to appeal and to object against the consequences that flow, and their families will have a sense of injustice, and the confidence in the judicial system will be undermined in our criminal justice system. So it is important that we do have legal aid available sometimes. There are a couple of other issues that I want to refer to. Legal aid costs are significant, and they're growing. What I think is wrong with the system at the moment, this sort of three strikes legislation drives up legal aid costs. There's no doubt that if someone is facing a charge for a crime which it would be one of their three strikes, then they will be more likely to defend that charge because they don't want three strikes. They'll be advised by their lawyer. They'll be advised by their lawyer that the consequences of this are so significant that rather than pleading guilty, they should defend it. And there is no doubt about that, in my view. So that's one area where you could be saving costs to the Crown by doing away with that silly 3 strikes legislation. Another area is I think that the Crown, through the police, needs to exert some control on how complex they make some of these trials. The prosecution is control of how long these cases, to a certain extent, just as the defence are, and the increasing complexity of all trials, be they civil or criminal, is something that needs to be addressed, because the quality of justice hasn't changed much. There are no more or fewer people getting off charges when they really are guilty and ought to be convicted, or being convicted when they are innocent. That sort of thing hasn't changed over time, and yet these trials become longer and longer, and therefore more costly and more costly. And every additional technical step that the prosecution takes, it has to be matched by a technical and costly act in defence on behalf of the accused, at the cost of legal aid if they're in receipt of legal aid, and at the cost of people's pockets if they're not in receipt of legal aid. So there is a need for rigour. How do you impose that rigour? Well, it requires a change of practice within the ministries. It's not actually so much a matter of law, it requires a change of practice. It also, in my opinion, requires judges to control their courts and to say that there is an interest in justice in the expeditious conduct of proceedings. I said yesterday, and I still believe, that the quality of justice cannot be divorced from its accessibility. If you have a fantastic but inaccessible justice system that no one can afford to access, you're actually not serving the overall interests of society in just resolution of disputes, whether someone should be convicted of a crime or not convicted, or whether it be the resolution of a civil dispute. So you have to control the cost of justice. So you need rigour within the prosecution. You also need rigour in the court by the judge, controlling their court. The judges must control their court. I saw a change during my period in practice when judges moved from being pretty strict, growly, generally old men on the bench, but my goodness, they'd had a sense of fairness. They had a sense of fairness, and they controlled their court. And if they saw a lawyer taking too long, or someone trying to delay something come on for trial, or making it too complex, or asking too many preliminary or interlocutory matters prior to trial, they stood on it and they stopped it. And it's their right to, it is their duty to, if they're going to cause the efficient administration of justice. And I think our justice system has gone back in that regard, and we need to get some of that rigour back. We see the increasing length of judgments. Now, do you know that we're only about 350 decided civil matters in the high courts in New Zealand, and the whole of New Zealand? Mr. Chairman, 2 minutes. About 350, between all of those judges, 350 civil judgments in the whole of New Zealand that were defended issues. You know, there are not enough matters coming to trial because the cost of trial has become too high. It's covered civil as well as criminal jurisdictions, this bill, and legal aid is but one part of what you need for a cost-effective and fair and just system. You must control the length and cost of processes. Despite the fact that we've only got 350 judgments in the High Court, I was told, you look at the length of the law reports and they're just as long as they were when we had far, far more decisions coming out of the High Court, because the length of every judgment has increased. And too many of them read like books. Too many of them read, in my opinion, like academic treaties. And it is important that you have the occasional academic look at a point of law, but that's actually not true of most cases. Most cases can be decided relatively simply on their facts without embarking on some jurisprudential consideration of the finer points of the law. So we need more practicality at that end of the justice system as well. Mr. Speaker, the Legal Services Bill, insofar as it changes these rules for preferred counsel, I think is a valid attempt to control expense, but we ought not to be pretending that it's actually the fundamental driver of cost. The fundamental drivers of cost, whether they be in legal aid cases or non-legal aid cases, need to be controlled. The High Court rules and the District Court civil rules need to be changed. They are too complex. We don't have enough oral judgments being delivered. That's another step that could be improved through better judicial practice.
I call Kanwaljit Bakshi. Mr. Speaker, before I start my contribution,